My name is Emily Lamb, and I will be presenting the cases to the board for their review in today's public hearing. Members of the public, at this time, please take a moment to turn off or otherwise silence your phones and devices so the board can hear the cases without interruption. For these public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearing, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of Metro Zoning Code Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the Metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for Metro Nashville Network, it is imperative that anyone addressing the board come forward to the front table and speak into the microphone. And y'all will come up to this table up here at the front. All speakers should identify themselves by name and address and then make the desired presentation. The Metro Code requires 4 members of our 7-member board to establish quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of a BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you are required to obtain the permit for which you applied. A permit must be obtained within 2 years for board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have some preliminary announcements regarding deferrals and withdrawals. Case 2019-211 has been withdrawn. Case 2019-259 has been withdrawn. Case 2019-274 has been deferred to August 15th. Case 2019-285 has been deferred to August 15th. Case 2019-294 has been withdrawn. And short-term rental case 2019-236 has been withdrawn.
All right.
For the members of the public, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, then the case is recommended to the board for approval. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of these cases identified for consent, please raise your hand. Because my back is to you, since the microphone is facing this direction, please make sure someone up there sees you, or say out loud, "There's opposition," so that I can make sure I pull it from the consent agenda. If something is pulled from the consent agenda, we will hear that case in its regular order. Please note that on any sidewalk case placed on the consent agenda, the applicant has agreed to the planning's recommendations for that case. Mr. Chairman, these are the cases that have been recommended for the consent agenda. First, case 292 involving property at 1104 Fatherland Street. Is there anyone here in opposition to case 292? Next, case 2019-295 involving property at 4911 Idaho Avenue. Is there anyone here in opposition to case 295? Finally, case 299 involving property at 4321 Old Hickory Boulevard. Is there anyone here in opposition to case 299?
I was here and I had some references.
Okay, so we'll pull that one from the consent agenda and hear it in its regular order. So, Mr. Chairman, the cases that remain on the consent agenda are case 292 and 295. Staff would respectfully solicit a vote from the board at this time.
All right, we have a motion for the consent agenda. Is there a second? Okay, again, a motion. All right, we have a motion. Now we have a second for the consent agenda. Any discussion? All in favor, say aye.
Aye.
Any opposed? That passes. And I do think we should take a second to welcome our newest member, Tom Lawless, to the board,
Indeed.
who we have been eagerly awaiting, and we're glad you're here.
Welcome, Mr. Lawless.
Appreciate it.
Members of the public, if your case was just approved on the consent agenda, you are free to go. Please give our staff until Monday to process all the documentation associated with your appeal, at which point you may come into our office to pursue those permits for which you have applied. Mr. Chairman, before we move on to the cases to be heard, we would like to take this opportunity to recognize any elected officials who are in attendance. Councilmember Hager, would you like to address the board now or wait until the case is called? And then Councilman Withers.
Good afternoon, members of the board. I am coming before you today for case 2019-297 for property located at 233 Chapel Avenue, and that is a corner parcel at the corner of Chapel and Benjamin. The homeowner actually just called me just a moment ago and wasn't aware of the meeting location, so she is en route and hopes to find the Board of Education building and arrive a little bit later. But I do need to get back to work, so I appreciate y'all allowing me to speak on this one briefly now. This is a fence appeal. The homeowner had, from my understanding, received conflicting information from staff as to the nature of the setbacks that are required for a parcel. In other words, the fence requirements would be different if you were sort of on an interior lot versus being on a corner lot such as they are, where you have a setback from the side street. So there was some confusion there. In that confusion, however, it occurred. Fence posts for the fence were installed, and they believed that they were in compliance. I heard from some neighbors. Code staff came back out to revisit that fence with them. What I have let the homeowner know that I would support is that, given those circumstances, that I'm okay with them keeping for the rear fence to keep those fence posts where they were posted. They do sit back a little bit of a ways from Benjamin Street. They actually sit behind some trees. There is a little bit of a buffer, at least, from the side street. I'm okay with them keeping those fence posts that were installed where they are, as long as they reduce the height to also meet the code and stay out of the visibility triangles. So I'm willing to compromise with them on that.
And Brett, I'm sorry, do you know what the application I have says that they are right now have 48 inches for the first 14 feet, then 8 feet to the rear. So you're talking about that after 14 feet.
That's correct. I'm talking about the rear portion.
The rear part.
They also had installed not quite to that height, but a front fence.
Yeah, and that was supposed, they're saying 48 inches, and so I don't.
And my understanding from the applicant is they're going to remove that entirely.
Okay, so, and then when you said you would support it to code height, is that 8 feet, or do you know is that?
My understanding is that the opaque fence height would be 6 feet, although they can go higher than that. And that they have, these days, the newest fence design that lots of people like is to have the horizontal slats rather than the vertical ones that we used to have. So what I've observed is that they have removed some of the horizontal slats from it. They may also keep some of that height to do like a lattice or something like that, but from that visibility standpoint. But you're correct. It is that back portion
Okay.
that is away from the actual corner. Chapel Avenue itself is at a diagonal, and then Benjamin Street does a dogleg, which we have many of here. And it is a dangerous intersection, so
And so
they've
you
agreed
don't
to remove
support the first 14 feet, that small fence?
Right.
And that was I think that we did get some letters that said, hey, there's some safety concerns and visibility concerns, and a 4-foot fence is a pretty tall fence on a corner, so.
That's correct, yeah.
All right, so you're good with 14 feet back, with 6 feet with lattice, maybe if they go higher than 6, but
Right.
anything before
For the
that, no.
backyard portion, but not the front.
Okay,
Yeah, and
sorry.
I know it's a little bit confusing. The homeowner, I think, was a little confused. Perhaps staff were confused and neighbors were confused, but just wanted to say that I am willing to work with them to have the fence posts for the backyard portion not be quite 10 feet, which they're not quite 10, but they do sit back a ways from Benjamin Street, and they do sit behind some trees. We always appreciate folks keeping trees. So
Okay, awesome.
I'm willing to work with them on that, but the front fence portion in particular is a little bit concerning to neighbors just because of how difficult it is to navigate that corner. And it's my understanding that the applicant has agreed to that, and they should be here shortly, so.
Okay. Well, I mean, we may have some others that, every time we meet here during voting time, it gets a little confusing even for some of us. And so we tend to be pretty lenient. And if people don't show, then it just gets deferred to the next meeting just because we assume that they are down at Howard School voting and, where they thought they were going to be meeting.
Yeah. But we'd appreciate your consideration of that, and I think that will satisfy the homeowner. One of the next-door neighbors also wrote actually in favor of the appeal, so they have been reaching out to neighbors. They also, we had at that particular time, that's in the Eastwood neighborhood, and the Eastwood neighbors meetings take place the second Tuesday of the month. That particular June meeting that we had, the Metro Council also had a budget hearing, so I wasn't able to be present at that, but the applicant did appear at the Eastwood neighbors meeting to present their hardship as well. So we've had lots of neighbor contact, so I'm satisfied with that.
Awesome. Thank you. Any other questions for Councilman Withers? No, thanks for coming.
Thank you so much.
I don't believe I saw any other council members. Mr. Chairman, so absent any other announcements, we're ready to proceed with the cases to be heard. First case to be heard today is case 2019-278 involving property at 36 Shepherd Street. Before you is the zoning map showing the zoning of the property as R6. Aerial photography giving you a sense of the surrounding area in for this property. Site plan submitted by the applicant. And finally, photographs showing you the current conditions of the property. Is there anyone here in opposition to case 278? Seeing none, the appellant will have 5 minutes to make your presentation. Please be sure to identify yourself by name and address before speaking to the board.
Buttons on this one?
You're good.
Nope.
It's live.
All right. Josh Helmer, 1071 2nd Avenue South. Asking for lot size variance to build a single-family house as well as a front setback. I believe there was a house here back in the day torn down in 1993. I think the contextual setback that the average that should be is around 17 feet. We're asking for 14 feet. So we're just basically asking to build and move the house 3 feet closer towards the street.
Yeah, and this is one we've heard, right? We deferred this?
Correct.
And so the 14 feet puts it in line with the houses next to each other. And I don't remember the lot size piece of it from before. Is that?
It's like 25 by 130, so it's, I think, like 300 square feet short of what it should be.
The minimum for a legally non-conforming lot is 3750 square feet, and this particular lot is 3360, so right at 300 square feet.
And was there a home on this when you, was it?
No, I believe the home was demoed in 1993. So there's a house on the right side at 38, and then new level development's going to build at 34. But this is just a vacant lot right now.
And what was the dimension of the lot?
25 by, I think, around 130, 128.
There's a 25-foot lot.
Correct, yep. Several of them on Shepherd are that size. We have got permission to build at 18 and 16. This is just the next one.
So the required front setback is 17 feet?
I think that's what the average is, yeah, and we asked for 14 before we knew what the average was. So I'm not, the 3 feet's not a big deal. It's really just we want to be able to build on the property.
But you're asking for 10 feet now?
Nope, it's 17 and I'm asking for 14.
Okay. Okay, this,
So you said you had you'd built on 2 other properties, but were those before this board?
Yes, I believe 18 was approved maybe about a year ago, and 16 maybe about 8 months ago.
As lot size variances?
Correct. And front setback, yep.
and then you also want a variance on the rear setback too, correct?
No, the house will probably be about actually, it's not that far. It's probably about 70 feet off the rear. There will be a detached garage that will follow the 20-foot setback of.
Any other questions? Did you have anything else to add?
No, thank you.
All right, we will close the public hearing and discuss.
I would note that we do have a letter of opposition in the file. General opposition.
Right. Well, and I don't remember the other 2 cases. And so I just don't remember them. Not that, but I clearly was on the board. Whether I was present that day or not, I don't know.
Physically, but not.
Yeah, exactly. You never know. The 17 to 14. I mean, he said it doesn't. That he probably could live with the 17. That wasn't as important as the lot size, but also when you get into the averages, and especially that strange building that's sitting further back than the rest, I don't really have a problem with the 14 because I think it puts it in line with the others that are closest to the street. And the lot size. Yeah, that's a question I'll ask the rest of you. I mean, I think it's something we've been doing.
It's a 10%.
It is a 10% difference. I know we've regularly done it when there was an existing home. I think this home was there. There's testimony that there was a home there at some point in its history. And it's not unusual at all for us to accept a lot size variance if there is a home there. So I'm just curious to know what.
Do you have a motion?
Any other thoughts or discussion? Well, with no other thoughts or discussion, I will move that we approve the variances from setback to 14 feet in the front, and that the lot size requirement also receive a variance for the applicant to build a home on the property.
I'll second.
Have a motion, have a second. Any other discussion? All in favor, say aye. Any opposed? That passes. Good luck.
Thank you for your time.
All right, next case.
Next case is 2019-293 involving property at 943A 28th Avenue North. This is a request for a variance from the sidewalk requirements to construct an addition to a commercial building without building sidewalks or paying into the fund. Is the applicant here on this case? Before you is the zoning map showing the zoning of this property is CN. Aerial photography giving you a sense of this property and the surrounding area. Site plan submitted by the applicant for this project, and finally, the photograph showing you the current conditions of the property. Is there anyone here in opposition to case 293? Seeing none, the appellant will have 5 minutes to make your presentation to the board. Please be sure to identify yourself by name and address.
My name is Demetrius Wide, and the address is 943 28th Avenue North. I'm trying to build a barbershop in the back of the building. If I put a barbershop, I mean, if I put the sidewalk in, it would take up half of my parking space, and I would not have enough other customers to park in. So that's the reason why I didn't want to do the sidewalk variance.
I guess that, and ma'am, the planning department has agreed with you to say that they're fine with you keeping the existing sidewalk and making sure that it's ADA compliant, but they also had said, well, you should pay into the fund. And so I take it that's what you're,
Yes, and the reason why I said that is because I've not even started doing anything, and I've been paying out money since I've already even started the construction yet. And they was telling me I had to pay close to $8,000. And so I was just saying, is that over enough of time that I have to pay that $8,000, or do I have a certain amount to, time to pay it, is what I was saying, because I'm not sure. There's just different hearsay that I'm not sure how much I was supposed to be paying.
is there any? Yeah, I don't know the answer to that. The codes department should. I do believe.
I'm sorry, what was the question? I may be able to help.
I think she was asking about when she needed to pay, and it was kind of my impression that you had to pay before you got your use and occupancy.
You have to comply with the sidewalk ordinance before you get the final UNOs, either by virtue of installing it, paying in lieu, or if the board grants a variance, that's another way to come into compliance. But ultimately, compliance has to take place in some capacity before the final UNO can be issued.
So basically, but when you're done with construction, before the city allows you to occupy your space, you have to come into compliance with all of the right with the sidewalk.
I was just thinking that I had to pay that up front before I even get the business started. That's why I wasn't understanding.
Building permits can be issued before compliance with the sidewalk. So the construction can begin, but the actual occupancy cannot take place until the sidewalk ordinance has been complied with.
While you're up, I have a question. As I understand it, the new sidewalk bill went into effect on Tuesday?
The new sidewalk bill passed on Tuesday. It does not go into effect until September 1st. And that's by the language of the law. It specifically says it becomes effective September 1st.
I see. I didn't realize it would be a couple weeks. Under the new sidewalk bill, do we know if she would pay a different in lieu fee?
The in lieu fee is determined by, I believe, Public Works, and it's determined on an annual basis. So at this point, it's $150, maybe $152 per linear foot. That has not been changed.
Not been
So
No, and that's a good question, though, because that's one thing we don't know much about. And again, I mean, this board is not tasked with, nor is it responsible for giving advice, but we also often try to figure out what's in the best interest of all parties when we can. And there may be some cases that are coming up where it could be in their best interest to wait, and get their building permit under the new law rather than the existing law. And so I don't know how that would impact this person. But is there a way that we can?
well, I mean, the biggest issue I would think at this point is that it's July 18th, and that's a month and a half away before it becomes effective. So
Right.
if the time is not an issue for the applicant, then certainly she could defer her case until, I would say, at least middle of September to see if the new law would help her. But if time is of the essence, then she probably needs a decision rather than waiting.
Okay. Yeah, I don't know if that made sense, but there's a new sidewalk ordinance that is coming, and I have no idea how it would impact you. And as you just heard, if you have the time, it might be worth your while to defer this, one meeting so that you can find out how that would impact you. And it may be exactly the same. If it's exactly the same, then at the next meeting, we'll be back where we are. And
Well, I wanted to go on and start the building to start getting, built, so I guess.
And as I said, we can go ahead and, the building permits can be issued. We could defer at a meeting to look at the new law with her. Although we can look at the new law with her, it wouldn't be effective until September, but that she can then at that point make the determination if she wants to defer it further out or if she wants to go ahead and proceed. But either way, we can work with her within the next 2 weeks so that she can make an informed decision.
Okay, because like I said, I think your worst-case scenario at this point is what the planning department recommended, which is maintain the existing sidewalk, bring it up to ADA standards, and pay the in lieu fee. And so I think you know where you are there. And so if you would like us to defer it, we can defer it to give you the chance to talk with the codes department.
Okay.
And then, like I said, if worst case is you come back to us the 1st of August, and we're back where we are right now. Is that okay?
Yes, sir.
All right, then I'll make a motion that we defer this until the first meeting of August.
I'll second.
Got a motion, got a second, any discussion? All in favor, say aye. Aye. Any opposed? All right, good luck. Next case.
Next case, 2019-296, involving property at 1704 Bernard Avenue. This is a request for a variance from lot size requirements to build 2 single-family homes. Zoning map before you now shows you the zoning of the property is R8. Aerial photography giving you a sense of the surrounding area. Site plan submitted by the applicant. And finally, the current conditions of the property is photographed in recent days. Is there anyone here in opposition to case 296?
Yes.
So each side will have 10 minutes to make the desired presentation. Please be sure to identify yourself by name and address before making your presentation.
My name is Cheryl Lenning. I'm one of the owners of the property that my dad bought back in 1955. We were under the assumption, according to all the paperwork that I had sent to Jessica and to the board members, that we had 8,000 square feet to build duplexes on it, and paperwork that he had originally had back in 1977 stated R8 duplexes. We can't seem to locate that paperwork. Anyway, there have been several different variations of paperwork. The Tennessee Real Estate Board had him under 8,276 square feet that the lot was at Lennox Place. The paperwork that I just gave Jessica that I got from the Metro Maps and Zoning Planning Board listed as 8,086, I believe it is. And so we just want something settled in terms of the being able to build duplexes to live there. And with the upheaval in the 7,903 square feet that came in on a estimated survey from Mr. Hood, John Hood, who is known well here in town. And then another one he did later in May of last year came in at 7,800 and something. I can go to that paperwork, but I'm sure y'all have it there. And then we just would like to get a definite, it's a minute variance. The alley behind is not even used as a public alleyway. I sent pictures and everything. It's used as a parking lot. And you couldn't get up and down it if you wanted to. Back in 2003, NES came in. I was there at my dad's at the time, onto the property, took his back fence down, and cut a tree down on his property. And, then the fence was put back up, and it was never in the same place. It was short of the property line. So,
Ma'am, you said you were one of the owners at...
1704 Bernard Avenue, Nashville.
Yes, ma'am. But now, you wanted to make a duplex. Is this for you, or are you planning to live here, or what do you?
Well, this is, there are 3 sisters, all of us. We wanted to, that was our goal at one time, to do duplexes and everything and live there, the 3 of us.
Right. And what's your goal now, though?
Well,
What do you want to do with it?
It's not going to happen unless we build one really big house because of the variance in the square footage thing. That's where.
But I'm just saying, you want the ability to build a duplex so you and your family can live there? Is that?
Yes, yes.
Okay. And then I guess I have a question for our staff that how is square footage on a lot determined? Because it seems like that this came about from her survey.
Codes typically relies on the surveys that are presented.
So they present a survey and not what is listed in.
That's right. Because I actually am not certain, the zoning administrator, when he steps back in, may know, I'm not exactly certain how the property assessor makes the determination of the square footage of a lot. But when someone comes in with a stamped survey that has been done by a licensed surveyor, codes relies on that.
Okay.
So my predicament being here is to try and settle this and be granted the variance so we would have at least the 8,000 square feet, because that's the assumption we have been under for years.
And the lots next to you look like they're smaller.
They are. And my dad's property, except for the alley on the back that's not used as an alleyway that you can't get up or down, it backed on the alley on the back, alley on the side, and Bernard Street on the front. So there was great accessibility to the property.
Okay. Are there any questions?
I guess I have a question about, our paperwork says 2 single-family homes. She's talking about a duplex, and I don't know what the difference of that is.
Well, I just read that it is duplex. We went over, my ex-husband is a big-time contractor, and we went over and he showed me around East Nashville and everything where they're building on smaller lots than my dad's, and the house in the front and the common driveway and the house in the back, the duplex, or I call them duplexes. You may call them full houses. I'm in terms of like a duplex.
And so do you have any type of site plan or drawing or anything?
No, because that depended on the variance. So if it can't be the duplex, it's the 2 units and everything, then it will have to be one big one. So there were no plans done. I did not want to go to the expense of 2 different types of drawings when we didn't know if we were going to have the
You're
variance.
planning to tear the house down regardless?
Yes, the house is of no historical value. It was deeded to Nancy Rice back in 1905. My dad bought it in 1955 and lived there until his death in January of 2005. It is old. The repair of the house would be greater than almost the rebuild.
So the 105-year-old house is not of historic value?
No, no. There was nothing historic in the house. There's no big moldings. It was just strictly a 2-bedroom, 1-bath little bungalow when my dad bought it.
I mean, I know the street. I know
Oh,
the
do
area.
you? Oh, okay, okay.
Yeah, I had lunch at the International Market today and actually drove down the alley. I wasn't sure.
Oh, we had lunch there yesterday. Do you know they're closing?
Yes, ma'am. But I do, and it's really a sad thing. But they announced in the paper they're moving across the street, so that's a good thing. But I guess I was not, when you talked about the back alley being congested, I understood that, and I drove down the side alley, which was a perfectly fine alley, a little narrow, but it's a decent. That's a decent
It used to
alley.
be a lot more narrow than that, because when my dad had his 1959 Chevrolet, we'd ride down the alley with the windows down and pull the honeysuckle off the vines. That's how close it was way back then.
Well, there you go. All right. Are there any other questions at this point? Do you have anything to add at this point? You will have 6 minutes to rebut the opposition, which is here to testify that they would like for us not to allow you to do this. And so you can save that time for...
I'll save it, because
Okay.
I don't know what else I could tell you right now that,
Okay. Then we
Okay.
will save that time for rebuttal, and we'll hear from the opposition.
okay, thank you.
Opposition to this case?
Oh, is the mic on now? Can everyone hear me all right?
Yeah, I think just maybe talk as close to the mic as you can.
Okay. Hi, I'm Cynthia Hicks. I live at 1702 Ashwood Avenue. I'm president of Belmont Hillsborough Neighbors. In regard of the lot size variance, what we would like for you to do, we ask that you would encourage you to comply with the lot size requirements within the R8 zoning, and we respectfully ask that you deny this variance request in this case. Now, obviously, there's a concern about what is the actual lot size. We don't know that, but if indeed it is as it was reported here, we would ask that you deny this, this case. The lot size requirement that we have we respect that because it properly maintains the density and scope of the building in our neighborhoods, and we don't want to overbuild. In that little street that we have there, there are 6 small, very modest-sized homes. They've been there for a very long time. I think most of us know that little area. To overbuild that area would be a bad thing. It would be a strain on the existing infrastructure that we have. And with the base zoning parameters that we have allowed, that would definitely impact that. That's a small street, it's a narrow area. We like the level of density that's in that area, and we don't want to see it overbuilt. That is one of the primary issues in our neighborhood that we're very concerned about, and we would respectfully ask that you deny this request. We have some other folks that live in that area right next to that property, so I'll yield and allow them to speak.
I do have a quick question.
Yes.
It was testified that the home did not have any historic value. I would ask your opinion on that statement.
Well, being that I own a home that is 102 years old and another home in the neighborhood that's 98 years old, I think that all homes in that area that are of that age are definitely historic and worthy and valued. And that is what our neighborhood is all about. We want to preserve our neighborhood. We want to preserve the homes that are in our neighborhood. And even if they're small, little homes like these are, I still value those, and our neighborhood values them. We want to see those stay there because we like to have that mix of larger homes, smaller homes, and yes, I think all of those homes are valuable. Yes.
And if this board did find a hardship and allowed this variance to pass, are there any criteria that you would suggest that we consider as conditions of the variance that would be, that might address some of the concerns that you have expressed about density or historic, compatibility, that type of thing?
What I would suggest considering on this is that should you decide that it is okay to overbuild on this lot, that in itself will set precedents for all of the other lots to overbuild, and we lose the character that's on that street that we have established already, that have been there for a long time, and neighbors have grown to love that area. I would find that would be a dangerous precedent to set. It would mean that historic homes really aren't valuable in our estimation, and it flies in the face of what Belmont Hillsborough Neighbors is about. And to answer your question, obviously we'd have to see what the site plans are. We don't know what that is yet, but I would say we would not want something built, overbuilt, that's very large in size. It would need to it would need to fit into what is existing there, I would think.
So if by right they can tear the house down now and build up to code, whatever they choose, you would prefer that than having 2 homes?
Yes.
Okay. And I'm, again, just trying to figure out
Yes.
where everybody's coming from and what they...
Yes, of course.
Okay.
So,
Yes.
Ms. Hicks, this may be a question for the zoning administrator too, but if this home had historical value, I mean, wouldn't the Historic Commission step in and say it can't be torn down? Or am I wrong about that?
It's not in the overlay.
It's not in the overlay, okay.
Right, yes. So I could not speak to that.
Okay.
Yes.
I have to ask questions
Certainly.
while they're on my mind or I forget them. So.
Of course.
They might express an opinion like they have on some of the downtown mansions that are being torn down now to build buildings, but there's not
They have no jurisdiction.
they don't have an authority because it's the overlay is on 18th, I believe, and doesn't include that little section. And Boulevard and the restaurants, on Belmont are not included in that overlay. Anything else to add or any other questions from the board? All right, we'll hear from additional opposition.
Thank you very much.
My name is Kelly Rutledge. I live at 2018 18th Avenue South, or 2008 18th Avenue South. My house backs right up to this house. And so I've looked out my back window and thought about this a lot, the impact that it would have on us. And we do use that alleyway a lot, obviously, not just to take out the trash, but I walk my 2 daughters down that alley, and I don't agree with this because of how it impacts us. There will be a stress on parking. We already have a bunch of parking in front of our house from the restaurants and Belmont students, even though they're not allowed to park there, they still park there. Just with 2 houses on that lot, I couldn't see it being a very great thing. Also, there's a really pretty tree on that lot. I know that putting 2 houses on there, it's already going to be a tight squeeze, and I really wouldn't want to see that tree taken down because it shades my yard. Also, I bought into this neighborhood 2 years ago. I was pregnant. Me and my husband found it, and we fell in love with the character of the homes and just what they look like. And I understand the reason that someone would want to build 2 houses, but I don't like it for my particular neighborhood just because I like the character. In addition to that, every time I've seen a big rainstorm come, it looks like a lake in the back of this, behind their house, and I would see that it would present water issues possibly, and I just would like to see what the plan is. What would 2 houses look like? We don't have any sort of idea or image of what they would appear to be. So that's my take on it all.
Questions?
I have a question. Did you hear the applicant say that she wanted to build a duplex, not 2 houses, as was listed on the agenda? How would
Yes.
you feel about 1 large house or a duplex there? You keep talking about 2 houses, but I didn't hear her asking for 2 houses.
Right. We received a letter, and I thought when I read in the letter that it did say that they were going to do 2 houses. Maybe not. I would like to just see what they would look like, even 1 house. And I would like for it to look like the style of the neighborhood if they did do 1 house. I think that would be it could be really pretty, potentially, but we just don't have any idea of what it's going to look like.
Mr. Chairman, in case it's of some benefit to the board, of course, 2-family under the zoning code's current definition could include attached or detached housing, just 2 residences either way. So again, site plan specific analysis is certainly a reasonable thing to inquire about, but I did want it to be clear for the benefit of our board members, some of whom are newer, that could be attached or detached.
Okay. And frankly, the testimony is important, but if we approve a duplex, it's up to the applicant. If we don't approve a site-specific plan, they can basically take it and build a duplex, either attached or detached, right? I mean, unless we give specific criteria.
It's just the lot size, right? So all that you're approving today is whether or not to grant a variance on the lot size. What gets built after the fact would have to comply with the zoning code standards either way,
Right.
which also goes hand in hand with the prior expression of concerns regarding the notion of being overbuilt. The zoning code applies.
Right.
That will be built to the standards of the zoning code absent any other variance from the board at a later date.
Okay.
So may I add one thing? Your question, the detached duplex is going to look like 2 single-family houses. So I just want to make sure that everyone is clear on that, so.
Right. Okay. Did you have anything else to add right now?
That's it.
Any other questions? All right. Is there any additional opposition?
Thank you for your
Oh, we
time.
got 2. Okay.
Hello, my name's Joe Woolley. I own the property at 2006 18th Avenue South, backing up to this property. We've lived at the property and been owners for 13 years. We know the neighbors very well, the current neighbors. There's one sister that's here that we've known for our time that we've lived there. Just to give you a brief rundown on the history of this street, it was not included in the BHN historical overlay. It took, you had to have a threshold per street. They had 3 people sign on to it. There's 6 homes. They didn't reach they needed 4 to bring that street into our overlay. It's one of the only streets in Belmont Hillsborough neighborhood where I was a steering committee member for the 13 years that I've been there. But it's one of the few streets in the neighborhood that is not in the overlay, and it's not in the overlay due to that reason. They definitely are historical contributing houses to the neighborhood, but it's not in there for that reason. I oppose this. What we were sent in a letter was that there would be 2 houses built. That's all that we have seen. We would love to know what it would be built there if this variance does pass. Either way, we were very interested to know what would be built on these 6 properties behind us. As you pointed out, the other properties are not large enough to build 2 homes. This one is. I think it sets a precedent for the other properties there on what could be done. There have been developers multiple times that have come in and tried to buy the properties on Portland that this backs up to on the other side, trying to build massive complexes, apartment complexes. There was a time where Hills came in and they wanted to buy all 6 lots, and they couldn't get 2 of the owners to commit. We're near Belmont University. We've instituted permit parking. The more you pack in there, there's an apartment complex, there's the business district on Belmont, there's all the homes, and then Belmont. The parking issues are already there. The alleys that are being spoken of, we back up to 1, and then so it's a T intersection. The lowest point in Belmont Hillsborough neighborhood is at that T intersection. There's a storm drain. It is like a river when it rains because the entire neighborhood drains there. This would put a house back on that far corner, even covering up more land with development. We're concerned about that. And we've had the councilwoman, Berkeley Allen, has met me on site several times with Metro Water trying to alleviate storm drainage in this alley. We've met with Public Works multiple times to try and make this alley functional, the one that this property backs up to, not the one that runs alongside it. It's really kind of a no man's land back there. I think another house on the back or having 2 properties developed there would be a large issue. It would contribute to multiple problems. And then again, it's really whatever built will be outside the normal overlay of the neighborhood. We'd like it denied, but if not, then at least deferred until there would be a plan that could be like presented where we could actually have say if it was approved on what that would look like. My real concern is this house has been for sale multiple times in the last 13 years. It never goes through because of the asking price. People make an offer. There's more money that's been wanted. I have a friend that actually tried to purchase it as well. What we're worried about is this will be granted and then it'll be handed off to a developer because the developer doesn't want to go through this process of the variance. That's what we're worried about. If we could see what was coming, we might be willing to support a 2 homes back there versus 1 large one. But we just don't know, and it's the uncertainty that I think neighbors are most worried about.
Any questions? Anything else to add?
No, thank you.
Thank you.
Good afternoon. My name is Jasmine Francis. I own the property at 1702 Bernard Avenue that is just to the right of the property, just to the east of the property that's being requested for the
So you're on the
variance.
same side of the street, but next to it, okay.
I am. If we could go back to the photos of the 2 houses, like the trees and the house, I'd like to just clarify a few things that have been mentioned here that aren't accurate. So this picture, the photo of the trees is actually a photo of the house. So the photo of the house is actually across the street. That's a different neighbor. The property.
So the one that has the red sign is the house that you're.
That's right.
That's the one that they're talking about now. And you live to the right of that.
I live to that blue house on the very far right of the picture. That's my house. So this property, let's get back to the very basics. The reason we're here is because this property does not meet 8,000 square feet. If you look back through the deeds, every time the property's just at 7,800, just slightly over 7,800 square feet. There's one document through a divorce where a 5 and a 4 were interchanged. They were switched around. even with that air, it still doesn't meet the 8,000 square feet. So we're not here saying, does this meet 8,000 square feet and can they build on it? If it did, we wouldn't be here at all. I'm actually pretty neutral about what happens. I think that the main thing is that this property needs to be addressed. It doesn't have historical value. This property likely should be condemned. So the lake that was mentioned is real. The drainage is an issue, the buckets, the trash, the boarded up windows. And then when you look at it, there have been, since 2011, declining. That's when I moved in. There's a shopping cart, buckets and tires full of water. So this isn't a cute historic house in Hillsborough Village. I'm not saying that to be opposed or in favor of building something new. It just needs to be addressed. So I'm not here to tell my neighbors that they shouldn't build something else. One thing I also wanted to let you know that this property was listed on the market last summer as a two-family dwelling. So it got an offer within a few days. When they found out, the developer found out that they couldn't build two houses on one property, it fell through and they came to me asking for the land. I own 2 feet just to the left of my driveway, which is adjacent to theirs. 2 feet for the length of that property is the amount of land that they need, about 200 square feet. So there's some details that have been kind of, changed over. So whether it's 8,000 or not, whether it's historic or not, I don't want you guys to look at that little house on the top left corner and think that's the property we're talking about. It's not. There's some very real issues. I don't think they have to do with the variance board, but with health and safety on this property. But yeah, we aren't here because it's 8,000 square feet.
But your preference is that they build a single-family home and not build two?
Actually, I don't have a preference. I want this property to be cleaned up. If that means it has to be 2 buildings, that's fine. I bought the property next to it knowing that they couldn't build 2 buildings and that they might need to come to me to buy that land. I actually don't even want them to come to me to buy that land. I just want them to clean up the property. So if that means that they get a variance and they build 2 houses, that's fine. But I would like to see this property look like maybe the one across the street or the other ones on the street, not the bottom picture that you're seeing now, which you didn't even know was a house.
Okay. And so it sounded like did you do the research? You'd mentioned that you had researched deeds.
Yes.
And so you never saw evidence that it was more than 78-ish?
I saw evidence through the entire purchase of the property from the time in the 50s when it was purchased by the sister's father, that it was 7,800 square feet, and then all the way through. Last year they did 2 surveys. So yeah, there were pink tags all over our property. I'm concerned because the 2 feet, it's a small amount of space, but it's the space that I purchased. So when the surveys went through last year, when the property was under contract, they again confirmed that they didn't have enough space to build 2. That's why we're here trying to get a variance and talking about this. If the surveys had come back or the deeds had proven that there were 8,000 square feet, those developers would have purchased that, gone through with their contract, and we would all be done. They'd build whatever they want to build. I'm neither opposed to building 2 or 1. I'm opposed to the fact that this is the condition that our neighborhood has let this house get to.
Okay.
The lake is real, the mosquitoes, the possums, the rats. The condition of this property is unacceptable. So I don't want the board to think that we're talking about a little cute home in historic value.
Okay.
But I also don't want to lose the value of my 2 feet that are on that side of the property.
Okay. Any questions? All right, is there any other opposition? I think that our time is up, but we will hear back from the applicant. So you had said earlier that your intent was to build 2 homes for you and your family, and a lot of your neighbors have said that you've had many times
I
you've
don't know
wanted
where a
to...
lot of that came from. It went up for sale for the first time back last March or April or whatever. Anyhow, and there was great conflict between the realtor and a couple of the sisters and everything. So that the sign was taken down. That ran out. until the contract ran out. The water problem, Metro has been in there several times and done new sewers and stuff and had the alley torn up and everything else. And anybody that knows about building would know that a contractor would be responsible for putting in proper drainage and water and everything else. I know that from my ex-husband being a contractor. I'm not looking to tear up or redo or harm the neighborhood. Those little houses, just like Jasmine Francis just said, there is no historical value whatsoever in that little house. The Historical Society has stayed as far away from us as they could get. And the lady that spoke earlier, that lives that's with the Ashwood Association and everything else, she's 6, 7, 8 blocks from my dad's property. And I understand keeping a neat little neighborhood. I also understand in rebuilding and wanting to live in something new instead of trying to mend a house that's broken and repair and redo and all that. If there were any great value there, we would have opted in that direction to go first. So, and everybody wanting to see the plans, I understand that. But if there's not a variance, the plans are going to be different. And if you look on the map where the property was, back to where the property was, at 18th and Bernard, right on the corner, that lot was sold that used to accompany the Longcriers property. And there is a house built there now that there can't be 3 feet between Bernard coming down the hill to my dad's property and their property and their house, their property line. I could stand on the street and probably touch their house. Huge monster of a house. That's not what we're looking to build. And a contractor would know how to handle the water. You can build 2 great 1,200 square foot little places and have a great place to live and a great location.
So were you planning to develop this yourself? Is that?
Well, my ex-husband talked to me about that and everything. He said, and I said, I don't know if I want the headache. He had said he would help me. He's very well known. He's very established, been highly respected for years. Last major, huge job was the T5V terminal in Chicago, the international terminal that he did when we lived there. I don't know, but unless there's a variance, there won't be 2 houses or 2 small houses on the property. But then there will be 1 big one.
Okay.
So it's your drathers or your rathers or whichever way you'd prefer to jump. I'm not trying to disrupt anybody in the neighborhood. I'm not trying to tear up an old historical neighborhood. I live in a house that was built back in 1916. I love old houses. If there were any value there to this property, and what I seem to be hearing, and I don't mean to be detrimental to anybody or anything else, I'm very much speak up front and say, I hear a lot of people that don't, especially a lady from Ashwood, that don't live near the neighborhood, and these other people that want to see and control.
Well, and I'll just say, I mean, I know Ms. Hicks, and she's the president of the Neighborhood Association, which does represent that neighborhood, and was speaking.
I don't know. I didn't know there was an association.
And was speaking in that capacity,
Okay.
and is maybe 3 blocks away. It's not, I mean, it's a reasonably close neighbor, but is speaking in the capacity of, of the Neighborhood Association that represents the neighbors. And then you had 3 people that live in homes that touch your property. So, I think each of them certainly had a right to be there.
Oh, I understand that. I do. But they have to understand, too, that we not have a right to build on my dad's property that he left to us.
Right. And so, and I guess that I still am not 100% certain exactly, whether or not you plan to sell the property or you plan to develop it. I mean, when you first came in, you said you wanted to basically have a duplex for you and your family.
Yes, and
And
2 houses, yeah.
But
Yes.
then you said last year you put it up for sale, and you just said you may or may not develop it yourself.
I wasn't a
So I
party
guess
to
I'm not.
that. I had to come on board later because of the 3 owners. That was not my purview, so.
Okay.
But anyway, it's not listed now and has not been. And I don't know the thing about the divorce. My dad remarried after my mother passed to a woman who had severe mental problems and everything else, and alcoholic, and they divorced, and she was never part of that house, so I don't know what that was about.
Okay. Any other questions? All right, we will close the public hearing and discuss. On one hand, the variance request is a fairly small percentage, and that often has some weight. Usually when I look at it in terms of how does it compare to others, and often the properties that are small percentage difference are the smaller lots in the neighborhood, not the larger lots in the neighborhood. And this one that is close is the larger of the 6 in that area that the neighbors have talked about. I don't know how it compares to the others on 18, but it definitely appears to be certainly larger than 4 of the 6. I don't know how it stands with the one across the street, but it appears, at least on the graphic that we're looking at, to be larger. So I'm not sure that falls in the favor. And we usually, and again, we have a new board, and so I don't know how the new board feels, but in the past, the board has taken into consideration these things, particularly when there's no neighborhood opposition, or even if there's neighborhood support. And I think that with all the adjacent neighbors expressing concern, I tend to think that, you know, if you need a variance, then it's not an unreasonable request to have the neighbors know what you're going to do. And I may not have been hearing things exactly right, but I still don't know, and I asked it several times, I still don't know for sure what's going to happen, meaning I tend to believe that if we pass the variance, it'll go up for sale as a 2-family lot, and that's that. So I tend to think that maybe it needs at least more clarity before we approve a variance. But yet I think that there's a case for a hardship, but
May I say
no,
one
ma'am,
thing, too?
the public hearing's closed. I'm sorry.
I'm sorry.
We had a chance to ask all the questions, and
Oh, I just,
I'm sorry, yes, closed. We're in our discussion, and
sorry, I forgot to tell you one thing.
I have a question. I have a question for legal, I think, and I agree with everything you've said, Mr. Taylor. I take it that we can rely on the surveys that are in the packet. And we've had evidence that someone has looked at the deeds that all referenced a lot size under 8,000 square feet. And what about this? I take it this is a Metro document that the applicant presented, and it does indicate that the square footage is 8,096 feet. So I'm just unclear, you know, if this is all we had before us, is this sufficient to rely? What is the value of this document? How do we look at that?
I think because if in the absence of any documents that would say otherwise, then I think you could rely fully on that. The maps that are adopted that are used by the assessor's office, I think that question may have come up earlier. Those are the official maps that are adopted by the Planning Commission, and those maps are developed based on the best information that they have available. That's not to say that a surveyor may come in and come up with a different number or have a different version. And I think you have to weigh the evidence. I think the question goes to maybe not whether you consider it, but what weight you give it in light of the other information that you have available. But we adopt those maps every year by virtue of an ordinance passed by council as the official maps of the metropolitan government.
So,
I'm sorry, but I'd say it is safe to assume, though, that, you know, if they bring us, I mean, we wouldn't be here if this took priority over the survey.
That's true. Also, I was going to say now, we do have all that said, those are the maps that we rely on, and those are the maps that we use for assessments. we do have a disclaimer on the mapping page saying that these may not be, down to the letter or down to the foot accurate, because we're relying on aerial photos, we're relying on deeds that we've looked at from past to kind of come up with what we think the map should reflect. So I hope that answers your question. We do put that disclaimer on the mapping data.
It does. I think just for people watching, I wanted to clarify what a landowner can rely on.
Right.
Because these are important questions that she's come before us with. Thank you.
So I live a block from this property, probably closer than anybody except the neighbors there, and I think this is a difference of 109 square feet, which is 1.36% less than they're required to have, which I think is a trifling difference. 1.3% is just a trifling difference. This is a family that has owned this property for years, paid property taxes on it. I think that to impinge their property rights over 1.3%, 1.36% shortage is not appropriate. I think that, arguments can be made for and against density, but I think a lot of people believe density and having more housing and more affordable housing is a good thing. So I think I believe that the variance should be granted.
Motion, I'd like to second it.
I will make that motion.
There's a motion to grant the variance, and there's a second for that motion. Is there any other discussion?
The reason why I'm struggling to support Mr. Pepper's motion, albeit very well reasoned, is that I understand the argument for density, but density sometimes isn't appropriate in every place. And if the zoning law, albeit trifling, may not allow it, I think that the neighbors have presented a good argument on water runoff and infrastructure. And so density should go in places that can support it from an infrastructure perspective. And I think this one I'm kind of struggling with, even though it's such a small percentage. What kind of precedent does this set for the rest of the neighborhood? And because the historical overlay is so close, how does it impact the context of this neighborhood and the character of this neighborhood? I did find the neighbor's argument compelling, so.
If I could address that, the way I understand it, and the zoning administrator can correct me, what they can build there has to pass stormwater, it has to pass through other agencies besides us, and as I understand it, they're going, if they're allowed to build 2 units over there, 2 single-family homes, they're going to have to still go through a number of other departments, and so they would presumably eliminate that issue. Presumably, they're not going to let them build something that is going to contribute to the runoff adversely.
And I think in a perfect world, that may be true, but as someone who lives in a neighborhood with water runoff where a lot of new building is going on, the stormwater sometimes isn't addressed. And so I just think some places can hold density and some places can't, depending on its intrinsic character. And so I definitely agree with you that public works and stormwater do that, but as someone who has new houses going up around them and has more water runoff in my yard, I will say that sometimes it's in a perfect world, that's great, but sometimes in practice it doesn't happen.
I've got a question about the bulk regulations for R8 zoning. I have a printout of it here, and oh, you can't hear me? Okay. And the printout I have, and I don't think this has probably changed in years, is maximum building coverage is 0.445, so 45% of the lot can be built. Correct, okay. So if this was so if we granted the variance and they were allowed to make an HPR, would each part of the HPR have that 45% maximum building coverage? Or is that just total?
It applies to the lot. It applies to the lot because the table to which you're referring, 1712-020A, refers to single and 2 family dwellings. So for this lot that is zoned R8, If the variance is granted, then the 2 theoretical residences would still be restricted by the maximum building coverage, minimum setbacks for rear side, and of course probably contextual street setbacks, and then the maximum height as well. So the bulk regs remained unchanged. You get effectively the same box in which to build, if you will, just a matter of 2 residences rather than 1.
So we're not, so if this is granted, we're not allowing them to overbuild.
Kind of a subjective term, but yeah, they're still restricted to the same
There was comments from the
bulk regs.
opposition that we would be allowing them to overbuild.
Right, same bulk regs.
May I say something? I was impressed with the next door neighbor saying that this property had been allowed to deteriorate, and she was hoping that it would be cleaned up, I think were her words. And I'm more impressed with our own member, Mr. Pepper, who lives closer than any of us live. And I feel like if we don't approve this variance, then there may be months and months and months before anything is done there, and will further deteriorate. So I would think we're looking at trying to help the quality of the neighborhood rather than causing problems. And as Mr. Pepper stated, many other boards will have to give approval before anything can be built.
I'm still struggling myself, but it is, and I tend to agree with these thoughts, but it is compelling to me that typically when we have granted a lot size variance, it's so that we don't have a single property owner who has a detrimental impact to a lot size compared to the neighborhood, whereas in this situation, we are allowing this homeowner to potentially benefit in a greater way, financial and otherwise, than their neighbors. And so I'm struggling with that a little, but I'm open for
I think
discussion.
that really is maybe the key difference, since that most lot size variances that I recall, even the earlier one today, was to build a single-family home. And the sole reason for this lot size variance is to build 2 homes. It's the only reason. They can build 1 home now. The only reason is to take maximum advantage of their lot. From a property rights perspective, I get it. I do think it is a very small percentage. I think if the neighbors, if there was widespread support, I think had they come and said, here's a potential sketch of what we're going to do, and all the neighbors think it's great,
Right.
then I think that might put it in a different situation. But they really are asking for a situation that makes their lot different from all the other R8 lots around it, most of which are either too small that aren't in the overlay, and the ones in the overlay aren't allowed. And so that's the piece of it that I struggle with and tend to side on the tend to be headed toward the side of I can't say I would never approve this variance, but I think the neighbors deserve more information before I do, because you're getting an extra advantage that they aren't, because you are 1% off of the requirement when they, in a spot of the neighborhood that chose because of the small street, the situation we heard earlier about the overlay. So I'm apprehensive about it because, to me, I think that those questions are important, and I think the neighbors deserve to, and because of the fuzziness of what really is going on.
Mr. Chairman, being the newest person in here, I'm a little hesitant talking, but I haven't heard anything from the applicant that would cause one to disregard, in essence, the regulations and the limitations that are already there. I mean, we've got an 8,000 square foot. This lot, by a licensed surveyor, is under that, albeit 1.5%. I appreciate the information that Mr. Pepper was able to provide us, but you've got such opposition from the other neighbors. You have an owner that's obviously allowed the property to deteriorate. They haven't done anything. How is it going to be any better under two properties being put there, which is what they came in here initially saying, seeing how some of us were reacting, they pull back, going, well, maybe I'll just put a big house there. I haven't seen anything in this application that would lend me to support the variance as it's presented. It's a, well, trust me. Well, there's nothing there to verify except for it may work its way through other areas. And I don't want to kick the can down and dump it on someone else. I don't mind being the bad guy if need be. But in this instance, I've got a homeowners group saying, no, we don't like it. We've got a neighbor across the alleyway saying, it's a dump. We have another neighbor saying, well, I really don't care one way or the other. They can have one or two or what have you. I want it cleaned up because I've got bugs. Heck, I have possums crawling all over my place trying to get in my trash. I don't blame them. And nobody knows what's going to happen on it ultimately. So I'm not struggling with it. I'm pretty clear and open, so it ain't going to be unanimous, I can promise you that. But, and I just mention that as we go along, so.
We do have a motion on the floor and a second, and this is the discussion of that motion. Is there additional comments or thoughts? The motion and the second are to approve the variance. If there are no other thoughts, we can vote on that motion. All in favor of that motion, raise your hand and say aye. And opposed, raise your hand. So that motion fails 5-2. There usually are two paths at this point. One is to make a motion to deny a variance, and that may receive the votes if someone wants to make that motion, or to defer this case to allow the applicant time to meet with the neighbors and others to maybe have a more concrete, verifiable plan. I don't know what the will of the board is, but those are the two options that we typically would follow at this point.
I'm going to make a motion that we deny and let them start it back up and come again and provide the information, lay the groundwork this time. So
That would require that they wait 6 months, is that right?
If it is substantially the same project, yes. If there are substantial changes to the project, they'd be allowed to make new application, go through the notice process, and come at an earlier date than that.
Well, and I would
mean, your concern about it, and the neighbor's concern about it sitting there in the state it's in is going to last potentially for another 6 months.
unless someone files a complaint to have it.
Would you accept a amendment to that would allow the applicant to refile a more specific plan earlier than 6 months?
Oh, absolutely.
So the amendment would be that they could refile immediately. Well, I was just saying, to me, I don't know how the applicant is taking this conversation, but if I were to hear the conversation, I would hear that you need more neighborhood support, you need a more specific plan. However long that takes, if they can get that done in 6 weeks, that's fine. So to me, I think they can apply immediately. If they come back with the exact same presentation, then I think they know what the answer is going to be. So the amendment I would like to offer is that they can reapply without waiting 6 months, with the expectation that they have a much more specific plan for the property.
Specifically, would you mind including in there that you're suspending your rule as it relates to that?
And the amendment is to suspend the rule as it relates to that for this specific case,
Yeah.
if that's acceptable.
It's acceptable to me. I just do your groundwork.
Yeah.
I mean, bottom line.
I'll second that as amended.
All right, so there's a motion to deny this request, but allow the applicant to reapply with a specific, more specific plan sooner than the 6 months it would normally be required in this case. There is a second. Is there any discussion on that? Then I'll say all in favor of that, raise your hand and say aye. Any opposed? Or abstained? So that motion passes. So the motion, the variance request is denied, but you heard if you we'd leave the door open for you to have a more specific plan that,
House plans. Is that,
I think a more definitive plan for what you want to do with the property. And we can talk about that after, talk with Emily. We can pass our thoughts individually to her, and then you just talk with Emily next week.
show house plans?
Yeah, talk with Emily next week. And certainly any neighborhood homework you can do would be beneficial.
Next case for the board's consideration is case 2019-297 involving property at 233 Chapel Avenue. This is a request for variances with respect to fence height and location. My understanding is that the applicant has an amendment to her request that she'll make verbally. Is Ms. Clark here? Staria Clark? Is that you? Okay. So before you is a zoning map showing the zoning of the property as R6. Aerial photography giving you a sense of the surrounding area. This is the site plan that will show you what was originally requested by the applicant. As I said, she may have an amended request, but I'll leave that to her to address the board. And then finally, photographs showing you the current conditions of the property. You can see the bottom right. This would be her property where the fence has, I believe, construction of the fence has begun. And then up and down the street as well as across the street. Is there anyone here in opposition to this case? Seeing none, you'll have 5 minutes to make your presentation to the board. Please be sure to identify yourself by name and address.
My name's Staria Clark at 233 Chapel Avenue, Nashville, Tennessee 37206. And I need to clarify what we were asking for. I have never done a fence before, never done an appeal like this before, so I kind of made a couple mistakes in the beginning. The first variance request, we are still requesting that, but the height is not correct. We are requesting to keep the existing 6-foot fence and then put a 2-foot decorative trellis on top.
And that part is the one that starts 14 feet back, is that right?
Yes, yes.
Okay.
I think I measured 17 feet back from the corner of the porch. And I do have those measurements in here.
And that's the one that your council member, Brett Withers, came and spoke and supported that piece of it?
Yes, yes.
Okay.
He helped me come up with a remedy for this. So that's kind of where I base this entire plan on. The second part, fencing within the visibility zone, we are dropping that completely. So all of those fence posts are to be removed. There will be nothing in the visibility zone instead of trying to work around the visibility zone.
So if you were gonna build there, then you're gonna take everything out. If you were to build there in the future, you'll build up to code.
Exactly,
Okay.
yes, yes, exactly. And it would just look just ridiculous. It just wouldn't complement the neighborhood to work around the visibility zone because it cuts back into the property too much. So we're just dropping that completely.
And then the compromise that you worked out, or what you're asking for on that 6-foot fence, or the fence that exists is, I think you have a picture example of a 6-foot fence and a 2-foot trellis. That's what you'd like to keep on that back part.
Yes, correct.
Okay.
And that's on page 4.
Right, and that's what, and Brett came and said he's supporting that too.
Correct.
Okay.
Yes, yes. So that's the only thing I want to keep is the back portion of it. The way and why I want to do this, or I guess let me back up how this happened. I just went straight to codes and asked what we could build there. And I was given a traditional lot guideline, not a corner lot guideline. And I just built that, not knowing. And it was one neighbor, one codes complaint that brought it to our attention, and we got the violation. Once we received that, we stopped everything. So right now it looks kind of funky, but I didn't want to continue to do any work on the fence until after this hearing happened. And we were clear on what we could and couldn't do. So it's just kind of sitting as is. There is one letter of opposition from one neighbor, but it only relates to the visibility zone. So as long as that is remedied, he's okay with this. And then I think it's 3 or 4 letters of support from other neighbors. Right. The lot is really sloped. You can see on the right, so on the right picture, Benjamin goes up. And so all the neighbors on that street kind of look down into my yard. When I first got this property, I didn't realize how much traffic was coming through Chapel and Benjamin right there, there's a fair amount. And it's not so much I want to hide from my neighbors, it's the traffic that people are really looking like right into my side yard and right into our back porch and kitchen. So I would like to protect the visibility of my backyard from that, and moving it in or dropping the height of it does not give privacy because the street is higher than the lot itself. So on page 3 is my proposed plan, and it's just a 6-foot fence and a 2-foot decorative trellis, nothing in the front. I have off-street parking from the alley in the back, and there are several trees lining the back there. We're not cutting down any of the trees. I wanted to save all of those. And the back portion, I don't believe takes away from the integrity of the neighborhood at all. And I did attach, about halfway through the packet, the page numbers start over at 1, and there are some examples of other corner lots with similar fences. So I believe it does fit into the neighborhood. Historic did not advise anything on this. I do care about the historic value of the neighborhood, and that's why I included the examples of the other neighbors.
Okay, great. Any questions? All right, anything else you'd like to add?
I believe that's it. It's pretty simple. This weekend, we're taking out the front poles, and I just want to continue the 6-foot fence and then add the trellis in the back.
All right, we will close the public hearing. I think this to me seems like a good example of someone working with their council member and coming up with a solution that is acceptable to them, and the only opposition related, I think, appropriately to the sight line and the safety on the front, which the applicants agreed to not do. And this is one of those, the corner houses are tough because every other house on the street can have, the 8-foot fence right down, on all sides, but the corner has a different rule, and I get it. But it feels like it's a reasonable request, so
I'll move it.
I'll move
Accept or granting it.
that grants the variance for the back part.
Yeah, as amended through the agreement.
Okay, there's a motion. Is there a second?
I'll second.
Motion and a second. Any more discussion? All in favor, say aye. Any opposed? That passes. Good luck.
Thank you.
Last case.
Last case for the board to consider is case 2019-299 involving property at 4321 Old Hickory Boulevard. Before you is the zoning map showing the zoning of the property. If you can see it on there is R15. Aerial photography giving you a sense of the surrounding area. Site plan submitted by the applicant, and finally photographs showing you the current conditions of the property. There is opposition in this case, so each side will have 10 minutes to make their desired presentation. Please be sure to identify yourself by name and address when addressing the board, except obviously the council member. You'll have as much time as you need to make your statements.
And I guess just to be clear, the applicant, this was on the consent agenda because the applicant did agree with the Planning Commission's recommendation, which was to construct a 5-foot wide sidewalk along the property frontage as an alternative design that they coordinate with Public Works, and agreed to.
I believe the second part was, I don't have it in front of me.
Yeah, if the site's redeveloped or sidewalks are triggered in the future, the redevelopment of the site or site improvement shall incorporate appropriate site work to construct a sidewalk to current standards unless any variance is granted.
Right, basically, if any redevelopment occurs in the future, they would be required to
come up
again comply
yeah,
or
to
get
come up to
another
code,
variance.
right. And so they've agreed to do that.
That's correct.
And there's opposition to that, which is fine, but I just want to make sure that
That's
I knew
correct.
that I knew where we were.
That's
Okay.
right.
Larry Hager, District 11. This is my district. This particular cell tower is on, what they did is a permitted use. It was under a PUD. They amended the PUD, and then they came to you all for the sidewalk amendment. The only concern I have with the 5-foot sidewalk is in the future, if somebody else develops this property, then of course, they're going to have to comply with the new sidewalk ordinance and have to do that. The other choice would be if somebody comes in and develops the property in that area, they'd have to come back and ask for a variance for the 5-foot sidewalk. That's my biggest concern, is to put a sidewalk in there, because South Fork subdivision is to the north of this property. If you look on the map, and you'll see there's a path through there where people are walking from the South Fork subdivision coming down Ohiku Boulevard. And since and of course, as a councilman, a lot of times I look at undeveloped property like that, and I try to wait and see if somebody will buy the property and develop it where they're required to put in the sidewalk under the sidewalk ordinance. But in this case, if they're required, like they said, to put the sidewalk in, which they've agreed to do, then I would go back into and propose in the capital improvement budget to finish that sidewalk up all the way up to South Fork subdivision, because the activities that are happening in that subdivision, we have what we call the urban air, which is a lot of teenagers and kids go down there. We have the Speedway filling station there that stays open all night. And there's some other business that eventually are going to go in there. So a lot of people walk from South Fork down to that particular area. I'm not totally opposed to the 5-foot sidewalk. My only concern is that if somebody comes in and develops that down the road, they're going to have to either widen that sidewalk or tear it out and put a new one in. And that's my position on that.
So, I'm sorry, so you, I guess, ideally, what would your ideal solution be for them to put in the grass strip in the sidewalk, or?
Correct.
Okay, so your preference is that they go fully up to code?
Correct.
Okay.
Correct, because if I put into the CIB to finish that sidewalk all the way up to South Fork, then, of course, Public Works is going to make us comply completely with the sidewalk ordinance.
And do you know, I don't know, I guess we can hear in a minute from Mr. Hargis about, I don't know why the Planning Commission said the 5-foot. It looks like there may be a slope, or I don't know if it's a topography or engineering or anything like that.
I don't have a clue, because the cell tower is going in the back anyway.
Yeah.
So I don't see where that's going to be an interference, unless it's just the extra cost of putting in the wider sidewalk under the sidewalk ordinance.
Okay, awesome. Any other questions for the councilman? No, you're good, thank you.
Good afternoon, members. Joey Hargis, law firm Baker Donaldson, 211 Commerce Street. I'm here on behalf of our client, SCI Towers, regarding, I want to give you a little bit of background on why we're here. As the councilman alluded to, this is a commercial PUD. The underlying base zoning is R15. There was a commercial planning and development approved on this site in 1986, I believe, for 50,000 square feet of office space. Did not include, obviously, at that time, cell tower. I'm not even sure they existed at that point. Our clients came in, talked with the landowner about placing a tower on this site. So we went through the process of going to the Planning Commission, amending the PUD for the use. So the use has been approved. And what's before you today? Originally, my filing you see is to postpone any sidewalk construction on this site initially, given that cell towers are not pedestrian generating land uses clearly, and obviously we don't want folks coming to the tower. After talking with the Planning Commission, and it's noted, you can actually see it on the photograph. There's a footpath that runs through here. You can see it, especially on the bottom right photograph. So after a site visit and talking with the planning department, planning recommended to us, which I passed to my client, and they agreed to build a 5-foot sidewalk, principally due to topographic issues. And you can kind of see it in the upper left, how the site drops at this point for this. So our request, we've amended to do the 5-foot sidewalk with Planning Commission's recommendation, and then at some future point, if this property actually does redevelop out for a use that would generate pedestrian traffic above and beyond what's out here now, would be required to comply. Just for the record, too, the aerial photograph was a little bit off. That was a different part of Old Hickory Boulevard, but our clients do not own the entire green space between the subdivision the councilman talks about and our site. So just the sidewalk, if we put in, whether it's 5 feet, if you grant our variance, will be along the entire portion of our property the property owned by Levog that's there. But I had talked with some of the neighbors here this afternoon. They have some concerns that are outside this board's purview, but I'll save my 7:45 for rebuttal.
Well, and so, do you know how far off the road that footpath is? Is the 5 feet, is it within the 5 feet?
Yes, sir, it is. It is. It's probably within 3 feet of that curb and gutter. There's an existing curb and gutter network, so in part of the discussions I had with Public Works on kind of relaying planning's recommendation to the client, I talked with Public Works about whether we need to install new curb and gutter, and they said no, that the existing curb and gutter will suffice. We would build that sidewalk at the back of the existing curb 5 feet.
And but there wouldn't be a grass strip? And how much space do you have, and is it possible to do any kind of grass strip?
Well, in addition to the other part, and I guess the reason for the grass strip is sort of break up the visual part of it. The Planning Commission required us to install a landscape buffer A across the front of the property. I'll back up a little bit. Typically, these tower deployments, we install that landscaping around the perimeter of the compound, the equipment compound to screen it. Planning asked that we move that to the front of the property because Old Hickory is a scenic arterial. So behind this sidewalk is where we're going to plant the landscaping. And in discussions with the urban forester, I talked about the topo and the swale. Where that sign you see, we're going to actually be on the back side of that swale. There's a little swale that occurs
Right.
in this.
But I guess I was just saying, I mean, for me, it feels more safety issue, when I walk on a sidewalk, I'd much rather have the grass strip, not because of the tree, but because I'm further away from the cars. And so I know, I don't even know what the standard is on this street, ultimately, what size grass strip, but
Sure, I can tell you, it's a 8-foot wide sidewalk with a 6-foot grass strip.
and so I guess the question was, is, given the slope and the topography that, we can clearly see, is 5 foot could you not have a 2-foot grass strip and a 5-foot sidewalk, or something? I mean, is that
there may be some,
or a 3-foot grass strip and a 5-foot sidewalk? I mean, where is that spot so that down the road it may be more compliant than?
Certainly, there may be some space in there. Our key part is we don't want to get into the swell of having to then fill the land to bring it up there. So if we can stay within that space that's in there, there may be some room.
But
I can't imagine more than a couple feet at most, sir. So that was kind of the summary of our initial request, was to postpone sidewalks at all. Initially, what I filed in the documents you have was for some later use.
Okay.
Which this board has granted those types of variances in the past, not on sidewalks, but for other items. But if in lieu of, once we discovered, there's clearly foot traffic here, we agreed to install a 5-foot wide sidewalk here.
But you don't know where that swell starts?
I don't know the exact distance, no, sir.
To know whether or not it could be 3 feet or 2 feet or 1 feet or 4. I mean, you know what I'm saying?
Yes, sir, I do. I don't know specifically. The particular drawing I have doesn't have the grading plan attached to it, so I don't have those grades.
Well, yeah, because trying to think of a potential compromise, and so, okay. Do you have anything else to add right now?
I have nothing to add. I'll save the
there any
balance of my time
questions?
for rebuttal.
So as I understand it, you'll build it, and then you'll see if people come. In terms of this walkway, the sidewalk, if you were doing it as to the councilman's desire to have the strip. I mean, you don't want to have it completed at the outset, as Councilman Hager was saying. You want to see what's going to actually, what foot traffic may or may not.
Oh, no,
start
sir.
using it?
My request is amended. That was the initial request, that we not build anything at all.
All right, so now you're going to have the 5 foot,
5
but
foot, yes, sir.
no strip.
With no strip. And certainly if there's physically room to put in some space, we'd like to stay on the front side of that swale that's there. But we're agreeable to build a sidewalk across the front of our property. We're asking to match planning's recommendation of 5 feet.
I'm like you, I'd like to have that graph.
So, yeah, to your comment, Mr. Law, it's not that people are clearly using it now. There's no question about that. So, my initial filing, sight unseen, was I don't think cell towers generate foot traffic, but.
Wouldn't think so.
Any other questions? We will hear from the opposition.
Excuse me. Been over there just sitting and listening to everybody. My name is Randall Butler. I live at 629 Hardinshire Drive, which backs up to the property under discussion. This variance for a sidewalk was news to us, that even a cell tower was going into this very densely populated area. And I know the scope of this particular variance does not deal with the yes or no of a cell tower, but it's right in our backyard and we didn't even know about it. And most of the neighbors I've talked to are very upset about that, let alone them not wishing to put in a sidewalk. For this purpose, this is my photo I took of the frontage there that he's discussing. I think we do have at least room to put in some grassy, at least 2 feet, and then the 5-foot sidewalk. I'm like you, Mr. Taylor, that it's very dangerous to walk down Old Hickory Boulevard on a piece of concrete right next to the highway. I appreciate them willing to go this far with us after we voice extreme displeasure with the cell tower in general. We don't understand that we have 8 towers within 2 miles of this location. And
well, and I tell you, I'm happy that I'm not having to make a decision on whether or not that's possible or not, and that we're just talking about a sidewalk today. But
I understand, but we're very disappointed that we didn't know about this
And I
on the
understand,
front end. And we don't know what we can do about it. There's plenty of green space. This tower could be utilized. I'm not against people getting better service. I mean, if you just look at where this thing's going, it's going right in here in the middle of this very densely populated area. And it doesn't make any sense.
Well, I understand that. But in terms of the sidewalk, though, you would prefer at least some grass strip.
Oh, absolutely. We have a lot of young families that are moving in with baby strollers. Right now, they have to stroll through grass. And it would really be nice not to put them straight on a piece of concrete next to the highway.
Right, okay.
Thank you very much.
Thank you. Any questions? Is there anybody else that would like to speak out on this case?
Hello, good afternoon. My name is Ricky McQueen. I live at 304 Brandywood Court, which is in the South Fork subdivision, which is right next door to this property. A couple of things I'd like to say. One is I appreciate them coming back and agreeing to revise their request to build a 5-foot sidewalk. A matter of record is that the letter that went out mentioned Council District 14. This is actually in Council District 11. So I'm not sure if everybody was notified of this, but the wrong council district was mentioned. With regard to the 5-foot sidewalk, I'm one of those that do walk from South Fork to Lebanon Road to catch the bus. And I am one that walks that footpath, and all the way down to Lebanon Road, there is no sidewalk. We have to either walk in the grass or I walk in the street. However, contrary to what the gentleman said, I do believe that, because I have walked the path many a time, if I understand correctly, that the grassy area is first 8 feet and then 6 feet of sidewalk. Is that correct? Is that the code?
I think the code is 6 feet of grass strip and 8 feet of sidewalk.
There is enough room for that before the drop comes down. The drop, you see where the white sign is? The drop is even further back from the white sign. If the drop was there, that sign wouldn't be there. So there is plenty of room for the 6 feet of grass and the 8 feet of sidewalk. And so with this being probably a multi-million-dollar company, yet the young lady that was here before, who's a small business owner, is being asked to put in money for a sidewalk fund for her little small business. I think we can at least ask this multi-million-dollar, if not billion-dollar company to comply fully with codes and do the 6-foot grassy median and the 8-foot sidewalk. And if they have to build up the back to get that 8-foot sidewalk, so be it. They are generating a profit from it. The neighborhood would benefit from the sidewalk. Also, the other thing that he mentioned was that they were going to put fence, and maybe I misunderstood. They're putting fencing up close to.
No, it was called a landscape barrier, and that's planting, that's trees.
That's trees.
Yeah.
Okay.
Trees and shrubs and a landscape barrier is foliage that creates a visual block.
A visual block. Okay. I thought he was talking about a fence. I was like, no, that needs to be further back so we could have the open green space. But no, there's plenty of space there for the 6-foot greenway and the 8-foot sidewalk. And they just need to comply with codes. I mean, why not? That's how they got the special permission to put this tower there, was to agree to comply with this code. And now they're coming back. First, they didn't want to do it at all, and now they're trying to revise it for the minimum. I would prefer that they just do it fully. There's room. That's all. I think that's all.
Great,
Yeah,
thank you.
That's it. Thank you.
Any questions? Thank you. Any other folks like to speak on the opposing side of this? All right, we'll hear back from the applicant.
Members, thanks for having me back. As to the council district, I can't address that. Looking at the application, I've actually, on my application that I wrote, had 14 on it. So obviously, it's Council District 11. Obviously, Mr. Roten's not here, Mr. Hager is. So
Right.
I think clearly notice has been met on that.
But those are usually sent out from, codes will tell you who lives within a certain amount of feet, regardless of district and.
Yes, sir. And these notices, from the whole notice process, the PUD required a public hearing notice in regards to allow the use to begin with, and we had no one present. And my phone number's been on all documents, so no calls or anything to that. As it relates to the sidewalk, clearly as stated, after seeing the site, and you could see it, especially, I don't know if your monitors, that bottom right, there's clearly a footpath here. That's here. And we've obviously agreed to build sidewalks. The speedway, which is down at the corner, Councilman talked about on the bottom right photo, it's the gas station that's there. There are sidewalks in that. I don't think they are 8-foot with 6-foot grass strip, as I think that construction predates that requirement. But I think planning, and I can't speak to planning's exact, but I estimate I've seen enough, and you guys have seen enough of their recommendations. They felt that 5 foot was sufficient to do that. Certainly, we're agreeable to do a grass strip if there's physically room to get 5 and a grass strip. We'll be happy to agree to that. We just want to attempt to avoid grading in that along the back of that swell area.
Yeah, and I didn't necessarily anticipate that question coming up, or we could have given you notice to say, find out how wide, what that is, and like I said, we have always weighed reasonably heavily the Planning Commission's recommendation, which, which didn't have the grass strip. But like I said, my preference is, and we haven't talked about it, and I don't know if 3 others agree, but would be to have the maximum grass strip and sidewalk. And I guess the question is, how do we get there in the time frame that is good for everybody? And the councilman may want to come back and tell us if that's an acceptable compromise, or if he still would prefer to have it fully come up to code. But to me, at a minimum, it should be the maximum grass strip and 5-foot sidewalk within the space that you have. I just don't, but no one's been able to tell us the space, because we just didn't know that question was coming.
That was not anticipated before today. Let me add too that planning staff, and and you guys have seen it too, if they fully felt 8 and 6 was required, they would have told you so. I think if they felt that strongly that it's here, like I said, the initial application procedurally, it's not to muddy this. I actually made this request at the Planning Commission because I felt legally the Planning Commission was the body to ask this variance for,
Right.
not the BZA. But Metro Legal disagreed with me, so that's why I filed this appeal here, because Metro said this is the venue. So they're requesting that, given it's an old PUD. So as I stated in the testimony, originally it didn't make sense to build any sidewalk given the use that's on the property. And then after my visit to the site for the client on the client's path, it's clear there's foot traffic there. So we were agreeable to planning's recommendation. So the timing of that visit came after planning's recommendation.
And so, I guess the question is how, if we were to entertain, and again, I think that the councilman may want to talk to us after you, which is certainly fine. If we were to entertain a motion for, the maximum grass strip with maybe a minimum of whatever, I mean, do you need more time to get us a survey?
Well, I mean, I think it would be helpful for me to know exactly how much room I have to work with.
Right, and that's what I'm thinking too.
Clearly 5 feet, no problem. I don't know, and there is, even the neighbors testify, there's some space there. And
Right, but if it's 12 feet, then you may have,
Oh, sure.
if there's 12 feet before it really drops off, or it starts to drop a little bit, and you can say, okay, well, we can, I'm saying, I guess that's, it seems like that it might be worth a.
Sure, no, I'm happy to, if this board feels they need to postpone and get some more information, I'm happy to do so. Because just sitting here, I wasn't prepared to address.
Yeah, I mean, it kind of feels like there could be a good answer or an acceptable answer with a quick meeting with, again, I'm not trying to fill the councilman's schedule, but a meeting with the councilman out there to say, hey, what's possible.
I'm happy to meet Councilman Hager with a tape measure, and we'll go out there and measure it and see what's
Well, and just to see, because I think that would, well, and that may be it. I mean, that may be helpful to us, because it would at least tell us exactly where it starts to slope. And if everyone's agreeable with the footage of the sidewalk, you'll know what kind of grass strip you have. I think it's been established from planning that you don't have to do the curb and gutter, which is certainly may have a budgetary impact on the ability to push the sidewalk back at least a little.
If I could ask, Mr. Chairman, when, and I don't know right off the top of my head, when the next time the board meets?
I think it's August 1st.
August 1st, okay.
Yeah.
And if that's enough, that seems enough time, I think we can accomplish that in that distance.
Okay.
If that's fine.
Yeah. Okay.
Meet with him between now and then.
And then did you have anything to say, Councilman?
No, I'm fine. I'm willing to go out there and look at it and see where that drop is.
Okay.
And compare it to the one that's Speedway, which I know that was before the sidewalk variance, the new sidewalk ordinance was passed.
Right.
And we'll look at that, and I've got to look up the north of Hickory Boulevard toward the other subdivision to see how much space is up there.
And how that might tie in. Okay. But y'all, August 1st is okay? If we deferred this to August 1st? Sure. Okay. Well, I'll move that we defer this to August 1st to give the parties more time to. Second. All right. Have a motion, have a second. All in favor, say aye. We're done.
Thank you.
Mr. Lawless, don't get used to the short meetings.
Maybe I'm bringing something a little
One can hope.
Oh, goodness.
Well, and this should have been shorter.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.